Welcome back to Law News. I'm Jesse Weber. Thank you for joining us. With us now, what you were just watching was the Morris twins trial and the testimony of the victim in this case, Eric Hood, taking the stand. Again, this is the trial of Boston Celtics forward Marcus Morris and his brother Washington Wizards forward Markieff Morris. They've both been charged with 2 counts of aggravated assault, which are felonies in Arizona. You're not going to want to forget that because what we're about to discuss is very important in that aspect. The brothers are accused of beating up Mr. Hood outside of a Phoenix gym in January of 2015. They face prison time, but that's not all they face. They face game suspension according to their collective bargaining agreement. They are 2 major athletes in the NBA, and here to help me talk about all of these issues in this sports realm is sports law expert from the Buffalo School of Law, Professor Nellie Drew.
Good morning.
Good morning. Thank you for joining us. So, first question, I want to start off a little broad here. You've been following this case. It's a little bit different than what we've seen out there. It maybe provides some different implications for the NBA. Just as a general thought as you look at this case, what are your initial impressions?
Well, it's the first test of the new collective bargaining agreement. Now, significantly, the new collective bargaining agreement is very much like the last collective bargaining agreement in terms of disciplinary processes.
Right, and I want to talk a little bit about that because according to the collective bargaining agreement, there's what it says that if you are convicted of a crime, this is under Article 6, Section 7 of the NBA's collective bargaining agreement. When a player is convicted or pleads guilty or pleads no contest to a violent felony, he shall immediately be suspended by the NBA for a minimum of 10 games. People might look at that and say, is that a little too lenient? What do you think about that?
Well, that's just a minimum. So you've got to remember that a felony count covers a wide variety of charges. So that's just a minimum. That's a starting point. And the same article gives the commissioner wide discretion to impose anything else that he might consider to be appropriate.
Yeah, we're going to talk about the other Article 35 in a minute, but just about game suspensions. If these guys are found guilty, they are convicted of aggravated assault, it's a pretty serious crime, 2 counts, what would you imagine their suspension would look like?
I would anticipate you're looking at least upwards of a 50-game suspension just based upon what they have done in previous instances. I'm thinking back to the Malice in the Palace brawl, for example, where Ron Artest got hit pretty hard, and that wasn't even something that resulted in a criminal conviction. So I would anticipate that the commissioner has that on his radar screen.
And obviously this is going to affect these players in a very financial way, but explain a little bit more how that affects them, fan base, their ability to be traded to another team, their career at large. How does that affect them in the longer scheme of their career?
Well, as you intimated, I would expect that's the least of their problems in some respects. But certainly, you could expect that their contract might well be terminated. And then from there, the extent to which any other team would be willing to take a chance on them, that's a significant question as well.
And do you see these kind of agreements for suspension in other sports besides the NBA? How does it differ between sports?
Well, I think the NBA has done a very good job of having a consistent disciplinary policy. As I said, this new collective bargaining agreement doesn't change the substance of the old one very much, but the 1 or 2 wrinkles they did work out had to do with concerns that arose in previous years, which were not particularly well specified under the agreement. Having said that, it's been very consistently applied. It's not the same thing as what we've seen, for example, with the NFL, where there's been some considerable labor strife because the players don't know what to expect in any given disciplinary incident.
Does it depend upon the type of sport? Look, I wouldn't know, but I'm saying if, for example, is there an agreement, for example, the NBA versus, I'm just going to make it up, golf? Is there a difference between NBA and tennis? Is there a difference between baseball? I mean, how does it really differ when you play different sports? Is there a different expectation of athletes based upon what sport they're playing?
Well, certainly not in the criminal realm, but as far as the overall league goes, absolutely. And those expectations, I should say, are identified in a collectively bargained sense in the CBA itself, and also in any personal conduct policies or drug testing policies, for example, that might be agreed to as well.
And we've touched upon it a little bit before, but I want to expand upon it. Even if there was no conviction, there's an article, 35 of the league constitution, which empowers the NBA commissioner, Adam Silver, to suspend players for any conduct that does not conform to standards of morality or fair play, that does not comply at all times with all federal, state, and local laws, or that is prejudicial or detrimental to the NBA. It's a lot of words. For our audience, just can you explain a little bit what that means?
That means he's the big daddy. He gets to do what he needs to do to protect his game. And again, the NBA has done a very, very credible job over the years of employing that policy effectively and judiciously. And I think that's the key. If you are consistent and reasonable in your expectations and firm and appropriate in your actions, then you can expect that both players and ownership will respect the policy and behave accordingly.
So there is a difference between that and the collective bargaining agreement in terms of felonies. So for example, wouldn't it be possible that the Morris brothers, if they are convicted of a felony, an aggravated assault, we know that they are already implicated within that game suspension, the part of the collective bargaining agreement. But isn't it possible, or have you seen players plead guilty to a misdemeanor, a lesser crime? Then they say, okay, we're now subject to Article 35, we're subject to the discretion of the commissioner, and maybe there may be a little bit more lenient. Have you seen something like that?
I can't remember a case that fits the parameters you're describing exactly, but it's certainly true that the commissioner can then take action as he sees fit, even if they're not convicted.
There was, I think it was last October that Adam Silver, who's the commissioner, he suspended Sacramento Kings guard Darren Collison for 8 games following his pleading guilty to a misdemeanor domestic battery. Again, you have an option here. It's in a way, a lot of people don't realize that there's strategic benefit of pleading guilty to a lesser crime, even if they think, according to this case, that they had nothing to do with this. Their argument is that we had nothing to do with this attack. We were 100 yards away. We were in the side of the parking lot. We weren't involved in this. If they're really nervous about the idea that a jury won't believe them, their best bet might be to plead guilty to a lesser crime. Am I correct?
That's true, but certainly the NBA will have that information as well. So, as my understanding is, a large part of this case turns on the credibility of the witness. And that's something that Adam Silver will be very much aware of.
It's funny you should say that, because I was reading about this, that they, correct me if I'm wrong, the NBA sends officials to the court every day to see what's happening, what's the progress of it. They want to keep a straight eye on it. Am I correct?
Absolutely. I mean, yes, as you mentioned, these are two very, very highly visible stars in the NBA, and it's not something that the league is going to take lightly by any means.
And even, okay, let's talk, for example, if they should be suspended under the agreement, if they face some sort of penalty under the league constitution, do they have a right to appeal?
They do. They do. First, they have like a meet and talk type requirement, where the idea is to have a dispute resolution process that's a little less formal, in an attempt to at least narrow the issues of a particular appeal, if not dispose of it altogether. If that is not successful in resolving the matter, then they do have the opportunity to appeal, and that's a much more formal process, but it is within the NBA itself.
And what kind of arguments would you expect to make in an appeal like that?
I would imagine very much like you would in court, only the standard of determination is a little bit more lenient in favor of the players. They're going to trot out the same arguments about, as you just said, they were across the parking lot, they had nothing to do with it, the witnesses are not credible, et cetera, et cetera.
And how is this usually successful? For example, if somebody is, I'm not even going to say, I'm going to take convictions out. If somebody does something that is against the moral turpitude of the league, if they do something that is frowned upon, for example, if Tiger Woods was an NBA player and was engaged in extramarital affairs and was doing something that tarnished the league, you might see something where they might be guilty in the public eye, they might even be guilty of a smaller crime, but they might not necessarily face penalty under the league. Am I correct?
Yes, depending upon the circumstances. I'm hesitating because it's an entirely different situation when you're talking about domestic violence, as you probably know. There are now separate provisions in each of the leagues as a result of the Ray Rice situation. So that's a little different story. But yes, certainly that's true.
And how much pressure is it on the league to punish these players?
That's That's a very challenging question. And of course, again, it depends upon credibility. This is a difficult case because of that. This is not as cut and dried as some of the other incidents that we've seen over the years. This is not the situation in the locker room where the gun comes out, and you have absolutely, you have a criminal violation as well as something that no league would ever want to tolerate. In any situation. This is something involving, he said, and multiple different events that I'm not sure they actually have any specific evidence beyond the witness's testimony at this point, and that makes it very, very challenging for the league.
We were talking a little bit earlier about how there is that lack of evidence. For example, there was the whole motive behind this is apparently a message that was sent by the victim, Eric Hood, to the mother of the Morris twins, but we haven't seen that message yet. We don't know if it exists.
I was just going to ask that. Yeah. I haven't seen anything that gives us any idea what the text of the text is, if you will.
Yeah.
That's certainly very, very relevant. This is not Deflategate.
I agree, and it's but that's a motive. You don't text someone's mother, so that's a different thing. But
I also thought of that as well. Probably was the smart thing to do.
I'm curious, in general, collective bargaining agreements, do you find that the penalties that are instituted in them, is it a deterrent?
Oh, that's a great question. It's supposed to be. And of course, the question is, when you're disciplining always, are you attempting to do this for the benefit of the person who is engaged in the conduct, or is it to deter other people going forward? Now, the nice piece about the NBA CBA, if you forgive the acronyms, is that they do have the mandatory counseling sessions that are required of any player who they've reason to believe is engaged in some sort of off-court violent incident. And I think that's an important piece. And I would suspect that regardless of what happens here, that particular clause will come into play for both brothers.
As we sit here, I'm thinking, for example, that let's say I'm a player and I do something that's illegal, but you know what? I'm not so worried about the jail time. Maybe it's not severe. Maybe in a way I said, you know what? I don't feel guilty about what I did. The money is really where it hurts. Is there something built into these agreements besides the suspension that tax their flow of money even when they retire, or their income stream in some way from the league, whether it's the NBA or another league? Is there some way that it taxes their financial opportunity to make more money besides the suspension? Is there something else we're not thinking about?
Sure, the endorsement money. Absolutely, and we've seen that. So when Tiger Woods is a great example. When you engage in conduct that is not particularly appealing to the public generally, your sponsors are going to pull the rug, and all of those contracts have some sort of morals clause in them, usually very broadly drafted, that will allow the sponsor at will, essentially, to walk away if the athlete engages in conduct that is going to be reflecting poorly upon the sponsor's products.
It's interesting to see when you have these cases which sponsors pull out and which ones don't. I would always be very curious to know what is their rubric, what is their standard. Every sponsor is different. I would imagine there's crimes or things that they do off the court or off the field that they would say it was in bad taste, but it won't necessarily hurt my profit or my sales. I'm curious what your thoughts are on that standard where they say, you know what? That really didn't do it enough for us to cut ties with a major athlete like this.
Well, that's always a very difficult call to make, because you engage in an awful lot of work, as well as spend an awful lot of money as a sponsor to try to maximize your benefit from that particular affiliation. So it's not something that you walk away from lightly. Having said that, we're seeing that right now, right on the political front, where we see sponsors who are reacting to Mr. Trump's comments with respect to the NFL players protesting on the field. And some sponsors have chosen to walk away, and some have chosen to make statements, and some have chosen not to do anything at all. Mm-hmm. So it's a highly individual decision. Interesting.
I imagine when they made those protests that they would never have imagined that would have affected their sponsorship deals. Sponsorship deals. It's interesting to see how that works, because what people don't realize is, or maybe they do, athletes are in the public eye. They set the standard, whether they like it or not, for society, for young children. So every decision that they make on and off the field is reflected in that. And there are people that look up to the Morris twins, that watch them play, love them on their teams, and this reflects badly on them, and they impact society in one way or another. So it's interesting to see that, and the endorsements is a reflection of that in one way or another. I do want to expand a little bit more about the idea of the bad behavior. If you have something, we've talked, obviously you said there's a carve-out for violent crimes. Is there a carve-out for something like financial crimes, people that steal money, maybe embezzle, fraud? Is there something that's a little bit different? Does that hold a little bit of a different character under these agreements or the league constitution?
It varies from league to league. Typically, that would factor into the league's discipline in terms of the I want to say the nature of the incident that's being disciplined for. So to the extent that someone, engages in embezzlement, certainly, as you mentioned, it's going to reflect poorly upon that person and the league. But to the extent that it's not they're not engaged directly in a violent act upon another person, that would tend, I would think, to allow for a little bit more leniency in terms of the disciplinary process.
And if the Morris twins are convicted, sentenced to jail, are suspended, what would you imagine? How would they bounce back from that? How do they actually bounce back from that?
That's challenging. That will depend, I'm sure, to a great extent upon how lengthy the sentence might be. And when, you put a professional athlete in prison for an extended period of time, certainly their skills are going to tend to deteriorate somewhat. Having said that, we saw Michael Vick come back very successfully after his conviction for, I believe it was animal cruelty charges. And so anything's possible, and they're still quite young.
I know, and who would have imagined that would have happened? A animal cruelty charge? It was. You can imagine people might do certain crimes, other crimes, this, that, but animal cruelty, no, I don't think that he anticipated that as well, or the league anticipated that. We're here with Professor Nellie Drew, a sports law expert from the Buffalo School of Law, talking about the Morris brothers trial. We are talking about money today, and I am curious, Professor Drew, the idea the defense put forward is that these the victim, along with the witnesses that are testifying, are going after them for money, or going after these brothers for money, that it's there's a target on their back. What do you make of that argument?
Well, just reading the fact pattern, it seems like it could be possible. It sounds as if Eric Hood was a longtime associate of the brothers, and that he had some sort of financial ties to them. He was described by the defense, I think, as a runner, perhaps, or something along those lines, somebody who intended to essentially achieve financial stability through the athletic prowess of the brothers as they made it to the NBA. And it's certainly something that occurs in the athletic world. It's not entirely surprising to hear them make that argument. The question is what evidence do they have to substantiate that? Yeah,
I'm curious, because most athletes are, when you reach that level, you're doing pretty well. You're making some very good money. In your opinion, when you're watching this, and people that are accused of different crimes, do you see that often as the first defense that's put forward, that they're the victim, that they have a target on their back because of money?
Well, it's certainly something that the leagues anticipate. So during the rookie camps every year, each of the leagues has a seminar that they have the rookies go through, and part of it is to alert them to the potential for that type of situation. You mentioned them having a target on their back. Well, I'm not so sure it's quite that dramatic, but certainly they can be manipulated and used by people who do not have their best interests at heart. And that's something that they have to become accustomed to. Many times these are not, necessarily very mature or very experienced people, and the athletes need to take care. And then the advice they're given is to try to steer clear of these things. But in this case, for example, this gentleman, I use the term, lightly, I guess, Eric Hood, had been a childhood associate, I believe. So that's the type of thing that it's really hard to screen out.
First of all, it's very interesting. I didn't know that they go through seminars in a way before, when they become professional athletes, to be on the lookout for people that might target them. That's very interesting. I didn't know that. And you said Eric Hood. The big issue in this case is, what was his relationship with the defendants? Because the defendants are claiming, we had no ties to him. We had no past with him, while the state is saying, oh yes you did, you had a relationship with him. And I think that key issue about how well they knew him, the jury's only going to read through so much before they say there might be more to this than the defendants are saying. Would you agree?
Well, I think it's going to depend entirely upon how they come across in the witness stand and who the jury believes.
If you were representing them, would you put them on the witness stand? Would you put the defendants on?
I guess it would depend upon what I knew about what actually happened that night.
That is a very, very good answer. That's the smart answer, because there is a danger, of course, of putting the defendants on. And we were showing before the victim's testimony. In your experience, we here on LawNewz, we cover a lot of different trials. Sometimes they're very brutal murders, and we don't have the ability to interview the witness. We don't have the ability to have the witness take the stand. But here the victim take the stand, but here we do. Thankfully, it was just an assault. The idea that a victim takes the stand, there are dangers, there are benefits. What are your thoughts about it? Because it can either go really well or really poorly.
That's a good point. I think the benefit for, the NBA's purposes is the extent to which they can assess independently what actually happened. So, for example, the NFL was castigated for not interviewing or making available to Ezekiel Elliott the information that was provided against him in a domestic violence incident. Now, it's an entirely different set of circumstances. Typically, in domestic violence incidents, you may very well not have a situation where the victim is willing to come forward. In this type of situation, though, the league does have that capacity, and I think that would be very, very helpful to them in terms of determining what would be appropriate discipline going forward.
So in other words, they're waiting and seeing what happens. They're waiting to see how this trial unfolds because, as we talked about earlier, there is that Article 35 of the Constitution where the commissioner can take some measure against the Morris brothers for anything that they necessarily do. So isn't an argument to be made that as soon as an athlete is arrested, there should be some action taken, or do they want to wait till there's some sort of guilty verdict? Is the arrest enough? Is an indictment enough? Or is it a conviction that's enough? I'm curious because there are times when the mere arrest, the mere appearance of impropriety is impropriety. So the mere of doing something, the arrest itself, couldn't that be cause for discipline?
I'm just checking my CBA here. I believe it's the actual term, and I want to make sure I use it correctly.
Sure.
I believe the actual term they use is there's reasonable cause to believe that an off-court violent incident has occurred. That's the lowest level trigger. So if under Article 6, so if the league has any reason to believe, or has reasonable cause to believe that that's occurred, then the disciplinary process begins to go into motion.
Right.
And then the progress of that disciplinary process is going to depend upon exactly what you just identified, how far down the line it goes in terms of a criminal prosecution.
That could be an arrest. An arrest is reasonable. Arrest is reasonable. And again, there needs to be probable cause for that. So we talked a lot about the CBA today. If you were drafting the CBA, what would you like to see differently in it? What would be some recommendations? Maybe to deter this behavior? Maybe there's things that you see that are lacking? Or just generally, what would you like to see in the CBA that is not in the current version?
That's a great question. I think they've done a pretty good job this time around. We mentioned Michael Vick. They actually have identified animal cruelty charges in this disciplinary process as a basis for discipline. So, they've done a very good job of learning from past events and incorporating those experiences into the CBA in a manner that I think is pretty fair to both the athletes and the league going forward. Overall, honestly, I think it's a very strongly written document, and the best part about it, to my way of thinking, is the fact that it has been it provides the commissioner with significant latitude, and he has implemented it, and his predecessor as well, very, very consistently over time. And so the challenge isn't so much really in the language as it is, I believe, in the application, and that's where the NBA gets very high marks.
How often does it change? How often is it updated?
Well, usually you wait until the CBA itself expires. So anywhere from a 5 to 10 year period, depending upon how long the management and the union agree to make the CBA last. You can go back in and renegotiate aspects of it. It happened in Major League Baseball with the drug testing program, under congressional pressure. But that's a very rare event. Typically, when a CBA has been negotiated, you leave it alone and you wait till the next time it comes up for renewal. So
what events, besides, like you said, when we had the drug testing in MLB, what events would trigger a real dramatic change in the agreement? I can imagine, technology changes the way we get our information, the way we disseminate information. I'm sorry?
Ray Rice.
Yeah. And that's all that
They
needs to be
tried,
said.
it didn't work, and the NFL ended up doing that unilaterally. But yes,
Right. Okay, that's a fair statement. So yes, we've talked about the CBA, we've talked about the Constitution of the league Constitution, we've talked about the Morris Brothers trial. My final question to Professor Nellie Drew, who is a sports law expert from the Buffalo School of Law, is what are your predictions as of right now for the Morris Brothers case? Where do you see them going? I know it's still early in the case. The prosecution is still putting on their case. We are seeing some unreliable witnesses. There's a lot of evidence we haven't seen yet, a motive that's wish-washy here and there. But from this initial stage, where do you see the case going, and what do you predict happening for these twin brothers?
it's going to depend, I think, entirely upon what plays out in that courtroom. And once we see the evidence, then the NBA can take action accordingly. If they are convicted, I would expect at least a season suspension, and counseling is mandated under the CBA. If they're not convicted, I still think we're going to see some form of suspension. I would suspect.
So you're saying their saga will not end in the courtroom. They will still have something to deal with in terms of the league. They will have to answer in some grounds because, again, they were arrested, they were indicted, and now they are on trial. So it's not so simple for them. This is not the end-all, be-all, but it's possible they can bounce back, they can play some great basketball, and their careers can once again flourish.
Well, you always hope that that's the case. But, of course, if something did happen that they are culpable for, then the disciplinary process should be applied.
Final question. I'm lying. I thought it was my final question. Mine's my final question. The teams, the Boston Celtics and the Washington Wizards, how does this affect, obviously it can affect their brand, but what do they do in terms of who's going to replace these players? These are really good players. What do they do about that?
That's a hit in the balance sheet because, at the end of the day, these players represent substantial assets to each of their teams. And that's something that the teams are going to have to grapple with. They've just taken a huge loss.
And in terms of their brand, ticket sales, hurting their reputation, what effect would you imagine them seeing, these teams?
I don't think the impact is going to be substantial. This is not the same thing as, and again, I hate to be a dead horse here, but is like the Ray Rice or the Michael Vick incidents, quite honestly, where they were much higher profile in terms of the victim involved and the egregiousness of the incidents. But I would suspect that, the teams will act quickly to remove jerseys if indeed they're convicted from store shelves and try to get ahead of it, if you will.
That makes sense to me. Professor Nellie Drew, thank you so much for joining us. We talked about everything today, from the collective bargaining agreements, we talked about the league constitution, we talked about what would happen in this trial, we talked about other sports. You've been a tremendous help for people who are trying to understand a little bit more about this case, a little bit more about the implications for their careers, because again, the reason this is really taking heat in the media is because these are two professional star athletes. And I think you would agree with me. We just hope that we just want to see better from our athletes moving forward. We want to see them doing well on the court, the field, and not in the courtroom. So again, thank you so much for joining us.
My pleasure. Thank you for having me.
Thank you. Take care.